I'm just going to address your lordships very briefly on one point that my learned friend raised with me and wanted me to address first. It's section 43.2 of the Administration of Estates Act, page 8 of the authorities bundle.
Sorry, which page?
Page 8.
43.2.
So
we'll just read that to ourselves first.
Yes.
Yeah.
So anyone who's entitled, as against the PR, claims to be registered proprietor under the LRA 2002 may apply to court for directions, court may make vesting order, etc. I think my learned friend's point is that this would include cases where a stranger seeks to be registered. My simple answer to that is that this is really directed at, do you remember the daughter from the consultation document who becomes entitled to registration as proprietor because it's so long since the administration was concluded that she gets a right to be registered, being the sole proprietor. So, you know, for example, you have a will, specific legacy of a house to daughter. Once that asset is no longer required for the purposes of administration, time does run against the personal representative on my, you know, even on my case, because she's the sole beneficiary and she's entitled in possession. So she eventually becomes entitled to be registered as proprietor. So it's it's dealing with that case, not I might call them this stranger claims, and we know that because where this falls in the statute, you can see at the top there, part 3, administration of assets. It's to do with how the administrator of the PR discharges their functions within the estate. And then again, another pointer to that is the words may apply to the court for directions with reference thereto. That's a part 64 application for directions, in other words. So it's it's dealing with the admittedly unusual case where you can have adverse possession internally within the estate.
Okay. Right.
That was all I had on that point.
Yeah,
okay. So, my lordships, you have the skeleton argument of my colleague Kate Sweeney, who appeared below, who unfortunately can't attend. So I stand in her shoes, and I'm going to follow the course of that skeleton. While it's fresh in our minds, I will make reference, though, to 43.2, since we have that open. The reason I raised that is because on the face of that section, there is clearly no hesitation about the proposition that a person can apply to be registered as a proprietor of real estate under the Land Registration Act, i.e. by way of adverse possession, against a personal representative. My learned friend says that that may, in effect, simply just be a reference to the slightly obscure example which he has taken from the joint report. But in my submission, there's certainly nothing on the face of that subsection to indicate any such restriction.
Well, any person who has against a personal representative claims possession of real estate, just pull him there. I mean, that's what we're concerned with, not concerned with the rest of it. Doesn't, on the face of it, restrict the person or the types of person or categories of person or anything of that kind.
No. And any person, who as against the personal representative claims possession of real estate or to be registered as proprietor thereof under the Land Registration Act.
Yeah.
But in fairness to Moylan and friend, I haven't raised it with him. It didn't form part of my skeleton.
No, understood.
I'd simply noticed it this morning, and I wish for him to be appraised of that point, which I say is a powerful supportive point on behalf of the respondents, rather than to take him by surprise. Turning to the skeleton for the respondents, can I start at I think page 6? I don't need to deal with the facts. And we are in agreement. This is, in effect, an appeal on a very narrow point of interpretation. Does Schedule 6.12 mean that land cannot be adversely possessed if the registered proprietor has died and the administration of their estate has not yet been finalised? As I understand it, my learned friend for the appellants concedes that that doesn't apply if there is an intestacy prior to the issue of a grant. But his case is, once there is a grant, there is a trust, and therefore by 6.12, time can't run unless and until all the interests have fallen into possession. I'm looking at the top of page 7 of the skeleton, and the key phrase upon which the respondents rely is section 33 of the Administration of Estates Act. The first point I invite the court to note is that there is an unusual phrase in that the wording is, the estate shall be held in trust. And usually one would find the wording would be held on trust. And that may well be indicative that it's not intended to have the sort of more general, as it were, universal application that the appellants contend for. My submission is that the provision in section 33 is addressed to the responsibilities of personal representatives. So those are set out in the other subsections. And of course, as was noted by subsection 7, this section has effect to any case where the deceased leaves a will. The question arose as to whether or not that would apply to a partial intestacy. And of course, it's agreed that that is the case. Clearly, where there's a will, there's often a partial intestacy, for example, by way of failure to nominate an executor. But the question is whether that definition means that the wording used in paragraph 12 incorporates the circumstances which applied here, where there's been a grant of letters of administration taken out following an intestacy. And in my submission, that is clearly not going to be the case. The Land Registration Act doesn't of itself include a definition of the word trust or trustee. That, of course, could have been the case if there was a decision to include a definition. That could have been done.
I think the explanatory notes are referred to in your skeleton. And we don't have the explanatory notes, so we haven't been given them, have we?
No, I apologise. There's been an omission about that. But they're readily available online.
They are.
Um,
If we had, not all of us do, I don't, access to the internet. But the reason I'm raising them is at the end of the explanatory notes, there is a section, I can't remember what it's called, a section that deals with the meaning of words. Is there not? If you have it there.
Well, I have up the relevant explanatory note dealing with Schedule 6, subsection 12.
Only.
I'm sure I could find the relevant section that
Doesn't,
you're
it
looking
doesn't
for.
define trust.
Well, because it has in it trust of land. Land can only be held on trust for beneficiaries, either under a trust of land or settlement. So that's not a, this is part of the explanatory notes, and I haven't got all the explanatory notes in front of me because I didn't print them all out. But I wouldn't want that any relevant provision in the explanatory notes to be overlooked.
No.
Unless I'm barking up a...
No, not at all. It would clearly be a relevant explanatory note. I don't know if my instructing solicitor has
You found it?
access. No.
Do you have them or not?
I do. I could ask my clerks to print and run them over if that's. But it'll
I
take,
think it
take
might
a
be
while.
helpful,
Oh.
if you wouldn't mind.
The
I
glossary.
think it would be helpful.
The glossary.
That's what it's the glossary, isn't it?
Anything else? Because they're very long, of course.
No, well, I've got pages 51 and 63, because page 51 deals with paragraph 12, paragraphs 271, 272, and the glossary, the page I've got, 63, deals with settlement and trust of land.
So paragraphs 271, 272, and glossary
Yeah, but I would say page 51 and 63.
through to 63.
Pages 51, well, perhaps through to 63, yeah.
I'll ask my clerks. Might take half an hour, I imagine. So
Sorry, I should have raised it before, because it's under settlement. It says land can only be held on trust for beneficiaries either under a settlement created under the Settled Land Act or under a trust of land. I mean, it doesn't. It's not a. It's a glossary, not a definition. But I think we should have them.
yeah, I agree. I'm grateful.
Well, let's rather than taking time now, if you can get a message to somebody in your chambers to, or maybe you can send people, I don't know, if that doesn't work. That might be an idea.
While we're on that point, it's not fully reproduced in my skeleton, but it's short. I was proposing to simply read it out. This is the explanatory note dealing with the meaning of adverse possession.
Yes. So which page are we on, Mr. Rogers?
Mr. Roberts, I think I might have. The reference to the explanatory note is in the skeleton at page 11,
Yes,
paragraph 31.
yes,
So
yes, this is the
makes-
purpose of paragraph 12, yes.
Yes. So just to read out, it's short. Under paragraph 11, if an applicant X does not have to show that she's been in adverse possession for the 10-year period, provided that subparagraph 2 applies, it would thus suffice if, I'm sorry, I'm reading out the wrong section. Under trusts, that was the particular point. The purpose of paragraph 12 is that where there are successive interests, adverse possession by a squatter should not prejudice the rights of beneficiaries who are not yet entitled in possession. So where there are successive interests. The operation of paragraph 12 can best be illustrated by an example. And it gives the same example that is quoted from the, I think it's from the joint report. Land is held on trust for A for life, thereafter for B for life, thereafter for C absolutely. As a squatter goes into adverse possession of the land during A's lifetime and remains there. For as long as either A or B is alive, S will be unable to apply to be registered as proprietor of the land under paragraph 1. Indeed, it is only 10 years after C's interest has fallen into possession that S can make such an application. This is because S is not regarded as being in adverse possession until C, the remainderman, becomes entitled to the land. So my submission is that, backed up by what is in the consultative document and then the joint report, makes it absolutely clear what the intention of the draftsman in drafting Schedule 6, paragraph 12 meant. So, just as a reminder, a person is not to be regarded as being in adverse possession of an estate for the purposes of this schedule at any time when the estate is subject to a trust, unless the interest of each of the beneficiaries in the estate is an interest in possession. So the explanatory notes make it clear that that is addressed to the type of classic trust with which we're all familiar, where there are successive interests. I'm returning to the skeleton at paragraph 18, where it makes reference to the judgment below, where the judge concluded that on its proper construction, subject to a trust for the purposes of Schedule 6.12, did not include the situation which arises on the death of a person and the vesting of their estate in their PRs. I'm leaving aside for the moment the question about interest in possession. Yeah. And over the page, there's a summary of the reasoning of the learned judge. That an estate in administration is not a trust in equity, and PRs are not trustees in the conventional sense. That must be right. That certainly the PRs are not trustees in the conventional sense. The sense in which the trust is used in section 33 is to make administrators subject to fiduciary obligations in the management of the estate, but not to make that which is not a trust into a trust. And again, that's my submission. If Parliament had wished to extend the ambit of the trust referred to in Schedule 6.12, it could have done so expressly, as had been done in the Limitation Act. It didn't do so. And without this, there's no reason to extend the wording of trust to an estate and administration. And unless the wording of Schedule 6.12, unless the interest of each of the beneficiaries in the estate is an interest in possession, assists in the construction that beneficiaries are required, as in a conventional trust. I do submit that's correct. I don't think it's determinative, but I do submit it's important and useful in terms of the construction. And of course, the pre-legislative material, which I say is very clear and overwhelming in favour of the limited construction of the word trust. So I'm turning to paragraph
well, it would have been very easy, I suppose you'd say, in paragraph 12, if the intention had been to encompass trusts which didn't have beneficiaries, to just say, unless the interest of each of the beneficiaries, bracket, if any, is in the estate, is an interest in possession.
Yes.
So, I mean, you're right in saying it's not determinative, but it does seem to be predicated upon there being beneficiaries.
Yes.
All of whom all of them, or each of whom has an interest in possession. Yeah. Okay.
I'm turning to paragraph 25.
Yeah.
So it's the submission on behalf of the respondents that the best evidence of Parliament's intention does come from the consultation paper, joint report and explanatory notes.
Yeah.
And I don't know to what extent I need to take your lordships to those documents again. The reference at paragraph 26, I would invite the court to look at. That is at page 327 in the authorities bundle.
Yeah.
And in fact, the skeleton doesn't refer to it, but can I take you back to page 326, paragraph 1018, and about halfway down that paragraph, our proposed reforms, if accepted, could lead to the situation where he or she will acquire title to the unregistered land, but not the registered land. So they're grappling with the fact that you've got potentially different outcomes in adverse possession under the two different regimes. However, although such a result is apparently anomalous, we regard this as a reflection of the fact that there are two systems of land ownership in this country, which rest upon wholly different foundations. So, and it goes on, secondly, it will be necessary for practitioners to be familiar with two different systems. As we explained below, the application of the principles of adverse possession to registered land already differs in a number of significant respects from unregistered land. They make it completely clear that you're dealing with two entirely different systems. So it doesn't work to say, well, this is what would have happened under the Limitation Act. The Land Registration Act is an entirely different scheme, and one simply has to look at the Act itself to understand how it is intended to work. At paragraph 27, this is a reference, I think it's page 324, if my reference is right. Paragraph 1013, I think we looked at this morning. But it sometimes happens that a registered proprietor abandons his or her land or dies in circumstances in which no steps are taken to wind up his or her estate. My learned friend was for saying that this only applies in circumstances where a proprietor abandons their land or cannot be traced. Well, that's simply a heading. Clearly, this goes beyond that heading and it also talks about a registered proprietor who dies. And this is important in circumstances in which no steps are taken to wind up his or her estate. There's no reference to whether this is a testate or intestate estate, and there is no reference to whether a grant has been taken out. In fact, it specifically covers the circumstance where a grant has been taken out. Surely, because those are the only circumstances in which one can then proceed to wind up the estate. Mm-hmm. So this is an example, a specific example, where in the report they envisage adverse possession should apply and can fulfil a useful role. And it's not limited to a case where a proprietor has disappeared or cannot be traced.
The better point was that after consultation on that report, when the joint report appears, you see reference only to abandonment and not to death, and that's I think paragraph 14.6(2). So this particular feature of the report doesn't come back. We don't know why, but it's after consultation. I'm sorry, which? We were taken to page 373 of the bundle. Subparagraph 2 at the top.
Dispute or unwilling to take steps to evict, which has say been abandoned.
Yes, it's different circumstances perhaps. But there's no reason that couldn't apply also to the circumstance of where a grant has been taken out. But still there's someone unwilling to take steps to evict the squatter. And I also make reference to page 325. Again, the report makes reference to the sorts of cases that might arise include 2 where the registered proprietor dies and the property is taken over by her daughter who was to inherit it, but where no steps are ever taken to register the title.
What is that, sorry?
Page 325,
325.
1014
Yeah, 1014. Thank you.
Well, that's our case, really, isn't it?
Yes.
Because that couldn't give rise to the sort of adverse possession problem we're concerned with, because that's the person against whom possession is being sought is the personal representative and the beneficial owner, or the person entitled in equity ultimately. But that's the very person making the claim in that example, isn't it? That's a daughter who is to inherit anyway. So if you're going to apply the trust analysis, she is the beneficiary of the trust.
Maybe I've misread that. It wasn't my reading necessarily that means that it would be the daughter who could take steps. And it may be that I've misread that.
How are you reading it?
Sorry, yes, 1014. There is every reason why the person in occupation should be registered as proprietor. Okay, such cases do not involve land theft.
I think you must be right. I
Yes.
think my lord must be right about that. I'm not sure that is an apt analogy.
No, I on consideration, I don't think that really assists either way. In principle, it shows that the intention is certainly there, that there can be an application under the Land Registration Act for registration against the PRs who may well wish to oppose it for some.
Not on the basis of adverse possession.
It's very odd though, isn't
Well.
it? Because it does say, doesn't it, such cases do not involve land theft and denied registration could render the land unsaleable. Again, as we've already explained, adverse possession fulfills a useful function. So they seem to be contemplating that it is a case of adverse possession. But at the moment, I'm, like my lord, I'm slightly puzzled as to how 2 can be a case of adverse possession.
Yes.
It seems to be just a case where the registered owner dies, the daughter is the person who's going to inherit, but nothing's ever done about it.
Yes. And if there was a different PR, the normal course would be to take action against the PR to administer the estate. So perhaps that doesn't help us either way particularly. But what it does certainly do is it does show that it was envisaged that there could be applications against the personal representatives. It even framed as adverse possession, even though not naturally fitting into that. And I also make reference in the skeleton, I'm looking at paragraph 30, to the joint report, and that's, I think, a reference to 413 in the authorities bond. Yes. My learned friend has very efficiently been provided with the explanatory notes, and was asking whether it would be convenient to deal with that now. But at, well, 412 and 413, the pages that I was referring to at 1492,
We're in the,
in the authorities bundle at 412. And again, 412 makes it at 1492. The manner in which the bill deals with the adverse possession of registered land that is held in trust is necessarily different from the approach adopted in the Limitation Act because it rests on different principles.
well, that's the same point that you can't read across from one
Yes.
to the other.
And the last 4 lines of that, however, the solution adopted in the bill shares the same objective as the Limitation Act 1980, namely that where there are successive interests, adverse possession by a squatter should not prejudice the rights of beneficiaries who are not yet entitled in possession. It's again referring to the classic trust with successive interests.
And the Limitation Act deals with that expressly by reference to successive interests, as opposed to through the shorthand of saying where held in trust, but except where the beneficiary isn't in possession.
Yes.
Which provision of that, can you remind me, in the Limitation Act?
Schedule 1, isn't it?
Paragraph 9,
Schedule 1, para 9, isn't it?
yeah. Isn't that one?
Which is at 34 in the authorities bundle.
Yeah.
During that possession to any person in whom the land is vested as tenant for life, statutory owner or trustee, or to any other person entitled to beneficial interest in the land. Well, it doesn't use precisely that phrase.
No, but your point is that the solution adopted in the bill shares the same objective as the provisions of the 1980 Act.
Yes,
So insofar as there is a read across, it's the same objectives.
yes. And as I indicated before, lest there was any possible doubt about that, the explanatory notes which find their way into the Act itself to accompany the Act make that very clear as well.
Paragraph 271 simply uses the word purpose rather than objective, but otherwise it's effectively in the same terms.
Yes.
It doesn't refer to the Limitation Act, but otherwise it's in the same terms.
And I also make reference to 14.93 at 412, which again spells out the point about a squatter will not be regarded as being in adverse possession at any time when a registered estate is held in trust, as long as there are successive interests in the land. And it's only when the interest of each of the beneficiaries in the estate is an interest in possession that a squatter can commence such adverse possession. And it goes on to give the same example, which is quoted in the explanatory notes.
294 rather cuts across your argument that the words held in trust have any significance, I notice.
Yeah.
So our proposals in relation to adverse possession held in trust for successive interests.
Yeah.
Possibly.
Yeah.
So the pre-legislative material all points in one direction in my submission, and very strongly, and the explanatory notes even more so. And the flip side is true. If there was an intention on the part of Parliament to extend protection from adverse possession to the case of an intestacy where PRs take out a grant, that could and would have been made clear. There is no reason why it shouldn't be specified, and it's not.
No.
So the route by which the appellants get to their argument is fairly tortuous by reference to the 1925 Administration of the Estates Act and Talata. It's not the easiest of solutions, and there is absolutely no reason that Parliament would have left a puzzle whereby judges would have to follow a breadcrumb trail if they actually intended this Schedule 612 to apply to intestate estates once there was a grant.
And testate estates.
And on the appellant's case, testate estates from the date of death.
Exactly.
It doesn't, in my submission, make any sense at all that there would be such an odd situation. And in the case, for example, of a testate estate where the will isn't found for a number of years, it would fall into one category, whereas actually once the will is found, it would fall into another category. It's just one example of how there would be such a strange and unintended anomaly in my submission. So the fact is that this reference to a trust does not apply to PRs. It does not apply to executors who haven't taken out a grant yet. It is intended to be limited to and to refer to classic trusts where there are successive interests. And there's a good reason for that, which is spelt out in the notes and the joint report, which is where there are successive interests, the persons whose interest hasn't fallen in yet would otherwise be unprotected. And so there's a potential unfairness there. That's what 612 is addressed to.
Do you accept that it applies to a discretionary trust?
It seems to me it should, yes, that definition would apply to discretionary
Well,
trusts.
that's not identified in any of the pre-legislative materials, is it?
No, unless I've missed it.
It also isn't, therefore cuts across the explanatory note which say the purpose is to address the following. Well, that's not dealing with it's also dealing with something else.
Yes, well, I accept that the explanatory note cannot be read as being absolute, as it were. I think I accept that a discretionary trust is a true trust, and it's a trust where the beneficiaries don't all have an interest in possession. So it would apply, and adverse possession could not be achieved against land that was subject to a discretionary trust. I think it's fair to say that any discretionary trust can't continue forever, so it's got to be time limited, but there is effectively protection there. But again, the same purpose would lead to that conclusion. The purpose being that there are beneficiaries who don't have an interest in possession who would otherwise be unprotected.
Why doesn't that purpose apply in our case?
But simply because the situation that arises upon a death, both before and after a grant is taken out, is entirely different. It's not a classic trust.
Well, no, I see that, that's the structural, technical argument, but in terms of purposive approach, what's the difference between wanting to protect successive beneficiaries who don't have an interest in possession yet, and interests of residual legatees who will inherit the property but don't have a right as of yet?
Or may inherit the property, depending on whether another creditor comes out of the woodwork, for example. There's the difficulty that a residuary beneficiary may actually not have any interest at all. It may be that it turns out an estate is bankrupt, for example. So it's simply a different circumstance, different scenario. And there is always the right of the beneficiaries to pursue the personal representatives. They can persuade them to act if there's an issue about adverse possession, and they can sue them for breach of their duties if there's adverse possession which succeeds.
Can they do more than that? Can they require them to act?
I think that depends on the precise circumstances. And they require them to act in order to seek possession in particular.
Yeah.
They can certainly bring proceedings demanding that. So I think they can.
I mean, they can apply for some, to enforce the due administration of the estate, can't they?
Yes.
Does that include taking specific action to protect an asset, for example, by obtaining an order for possession?
I have to say I have not addressed that specifically, but it seems to me that that is the case. Because that would be part of the due administration of the estate.
It would be odd if you couldn't take steps, the personal representative couldn't take steps to protect the value of
Yes.
the estate. Or couldn't be required to take steps to protect the value of the estate. If there was an issue as to whether it was an appropriate or not an appropriate step to take, and maybe the prospective inheritors under the will had different ideas, there would surely be a forum in which you could go and resolve that.
Oh, absolutely. Under Part 64, personal representatives can bring an application effectively seeking authority from the court to take action if there's
Or not to take action.
Or not to take action.
Yeah.
I'm going to address the question about the meaning of trust. So I'm looking at paragraph 13 of the skeleton argument.
So in paragraph?
Paragraph 39. I have to apologise, on page 13. And this is addressing the nature of a trust and comparing it to the situation which applies with personal representatives. And it's the respondent's submission that Justice Freedman correctly identifies that there are certain very clear distinctions. So subparagraph 1, for a trust to exist, there must be specific property identifiable as the trust fund, a trustee and identifiable beneficiaries who can enforce the trustee's duties. In contrast, where a deceased person's estate is unadministered or in the process of being administered, whatever property vests in the PR comes to them in full ownership without distinction between the legal and equitable interests. And that is again a reference to Livingston. Those interested in the estate administration have no beneficial interest in any particular asset, but merely a right to compel the due administration of the estate. And that is clearly very different to the situation which applies with the trust. At subparagraph 3, PRs can only be appointed by will, or appointed and removed by the court, whereas the Trustee Act 1925 gives the power of appointing a new trustee to existing trustees. And that's a good example of the difference. PRs cannot appoint someone else. There's no equivalent power. Unless, of course, the will gave them the power. That obviously wouldn't apply in an intestacy. And there is a significant difference, of course, once the estate is complete, the administration of the estate is complete, and the PR's role ceases, and very often the same people become trustees under a will, this is. But of course, it's not unusual for the same people to be appointed, but it's perfectly possible for different people to be appointed. And if that's the case, it simply re-emphasises the fact that PRs aren't trustees in the normal sense. So subparagraph 4, in broad terms, the main function of PRs is to wind up the estate of the deceased, to get it in, pay all the debts, and then distribute the assets to the people entitled to them. Trustees, on the other hand, are intended to hold the trust property and administer it in accordance with the trusts which bind them.
Does this give rise to this point? A claim in adverse possession would run against successors entitled to the subservient land, would they? So if I have adverse possession of a strip of land owned by X, X sells it to Y, and I continue to have adverse possession, does my claim can the 10 years run over both the ownership of X and Y?
Yes.
So in the case of a estate, if it turns out,
I don't think that's controversial.
No, I thought in the case of an estate, point you made earlier, if the tax, for example, on the estate is such that they're going to have to sell the only real asset and it's purchased by somebody else, what happens to the claim for adverse possession if there's been a period of 5 years before the death, let's say 2 years during the administration of the estate, and then another 3 years afterwards in the hands of the new purchaser? Does that count for 10 years against the new purchaser, or do you have to does it start again once the new purchaser acquires it?
It doesn't start again unless one of the exceptions applies, such as it being placed into a trust with successive interests.
So if the appellants are right, it would have the effect of, as it were, stopping time running against a purchaser.
Yes. On the appellant's case, time doesn't run on an intestacy until the grant is taken out. And the date the grant is taken out, time ceases to run. And not only that time ceases to run, it's not as if if you're up to 8 years adverse possession, it's not as if it continues from 8 afterwards. No. It sets the clock back to 0. The skeleton sets out some other differences between trustees and PRs. I think the most telling one is at subparagraph 6. It's also the case that PRs need to assent property to themselves before they become a trustee of it, and the legal and beneficial interest estate is split. So whilst they are PRs, the legal and beneficial interest in the estate property is held by the PRs. If there are different trustees appointed, they have to assent the trust property into the names of the trustees, and then the trustees hold it on trust. So they hold the legal interest, but they hold the beneficial interest in accordance with the terms of the trust. So they are starkly different. And the point made at subparagraph 7. The fact that legatees and beneficiaries under a trust may have similar duties or remedies if a trustee or PR breaches those duties doesn't mean that an estate is in administration is a trust. And I say that's correct. There's reference to paragraph 40 to the case of Livingston, and it's quoted extensively. We looked at that this morning. I don't propose to take your lordships back to that. It is authority in my submission for the proposition that the beneficiary doesn't have any beneficial interest. And the quote there at the top of my page 15, because no trust has had as yet come into existence to affect the assets of the estate. And that's the reason why the learned judge on the first appeal concluded that it was correct to say section 33 of the 25 Act doesn't make that which is not a trust into a trust for all intents and purposes. I adopt what's set out in the skeleton about the effect of deeming provisions at paragraph 43. If, as the appellant suggests, section 33 makes an estate in administration a trust at large, and it would be up to Parliament to narrow the meaning, there wouldn't be any need for these various deeming provisions. So there's no deeming provision in the Land Registration Act 2002, and it's our submission that that's not an error. So I'm turning to page 16 in my skeleton, and the issue at paragraph 45 about the absence of beneficiaries. It's not, he held the wording of the exception assists in the construction. I think I addressed that earlier. That beneficiaries are required as in a conventional trust, and without that, there cannot be a trust for the purposes of Schedule 6. And at paragraph 47, it addresses the point about discretionary trusts. Paragraph 48, rather, discretionary trust is considered a trust at equity, and it's got all the hallmarks of a trust, i.e. an identified trust fund, trustees, beneficiaries, and a split between the legal and equitable interests. The question about charities is an interesting one. So at paragraph 47, that is addressed. The joint report, and that's, I think, page 388, if I can rely on my note, makes particular reference. It's paragraph 5 at the top of that page. The relevant paragraph is 14.33, so that starts on 386. Persons on whom the registrar must serve notice are, and then subparagraph 5, such other provisions as rules may provide. And the sort of persons or bodies we have in mind may have a supervisory role in relation to the property. So this is in addition to the registered proprietor. If the property was held by a charity, the registered providers would be the charitable trustees. But this might include the charity commission in relation to land held in charitable trusts. It clearly envisages, in my submission, that you can have adverse possession in circumstances where the property is held on a charitable trust.
Was this carried through into any provisions in the Act or rules?
That's an interesting question that I'm not able to answer, I'm afraid.
I'm wondering if the rules provide
Rules
who
may
else
provide.
you need to provide notice to, for example, personal representatives, or the fact that they do or the fact that they don't might shed some light on it.
Yes.
But we don't know what the answer is.
I don't, I'm afraid.
What are the rules that are made under the Act?
They're actually referred to later on in paragraph 17. They are the Land Registration Rules 2003, so made the following year.
We haven't got them there, have we?
No, I don't think we have.
No. Not complaining at all, but
I seem to recall they're fairly lengthy as well. I
Yes,
haven't looked at them
I'm sure they
recently,
are.
and I haven't looked at them, I must
No.
confess, in relation to this point. I am not going to take your lordships through the rest of the skeleton in great detail. Broadly, turning to paragraph 56, the appellant's interpretation would lead to a two-tier system and an unwarranted distinction between land held by registered proprietors who die testate and those who die intestate. And one can see that the submissions of Moylan and friend are that if this was a case where there had been a will, there would immediately be executors identified and it would be subject to a trust. Even if nobody actually had found the will, the executors could then decide to do nothing for years and years, but you still could not have adverse possession. Whereas here they accept on an intestacy, there is the possibility of adverse possession until someone takes out a grant of letter of administration. That, in my submission, would be clearly anomalous, odd, and inexplicable. There's certainly no rationale anywhere, either in the reports or in anything Moylan and friend has referred to justify such an oddity.
Yeah.
And I echo what's paragraph 57. There's no discernible justification for such a distinction. The mischief which retaining adverse possession was intended to address, land being rendered sterile, is a risk in circumstances where nothing is done to finalise the estate of a deceased person, regardless of whether that person had a will or not. And in my submission, the sections we looked at previously, where there's reference in the joint report to the circumstance where nothing is done to wind up an estate, that seems to apply, in fact, in both cases, testate and intestate, after a grant has been obtained, because you can only start to wind up an estate once you have a grant. The notes don't seem to make any distinction. Sorry, the notes, the joint report,
Yeah.
consultation paper, and the joint report do not contain any material in my submission which would justify such an anomaly. And over the page at paragraph 58, I won't go through all these points, but the key point is that the function of a PR is to wind up an estate, whereas the function of a trustee is to hold assets on the terms of the trust. And whilst trust can last for many years, the intention certainly is for estates to be administered promptly. And for example, at 3A on that page, PRs have an express duty to actively collect in the deceased assets. Generally, any income, inheritance tax rather, must be paid within 6 months of the date of death, which is a very long-standing provision. PRs are only given 1 year from the date of the deceased death before they can be called upon to distribute. And if pecuniary legacies are not paid within a year, statutory interest becomes payable on those legacies. There's just an entirely different scheme for PRs and for trustees, and PRs operate in circumstances where, of course, we see examples where the administration of a estate can take many years, but that's not the intention. The structure of those provisions set out is one where PRs are intended to. They're supposed to get on with it, and that's hence the phrase "the executor's year." And I will turn briefly to the question of issue 2, which is the question of whether there is, if it was held that the PRs do, that does constitute a trust and it is covered by 612. Then there's the question of whether or not it can be said that the exception applies. In other words, whether the interests in possession are held. I have to say, I struggle with this part of the judgment below.
That's very frank, Mr. Rogers.
I
think you're not alone in that.
Well, I don't see a great benefit in spending a lot of time arguing about it. The whole point of the respondent submissions is that there is simply no trust here at all.
Well, the whole point of your submission, the judge was right on the first issue.
Yes.
Clearly right on the first issue, therefore the second issue doesn't actually arise, and so we don't really need to deal with it.
Yes. But
that's really what it
if you're against me on that, I think I can do no more than observe that part of the difficulty that the judge on appeal had was the issue of Schedule 6, paragraph 12 was never raised at the trial.
No.
So it was not addressed, and there was simply no proper evidence about whether there was an interest in possession or not. And
it's a problem that was caused by the fact that the appellants represented themselves. It wasn't really until a later stage that these things emerged.
They rose the question that's before the court now on the first appeal, but not at trial.
Yeah.
And as a result, there was no actual evidence. The question was also complicated factually by the fact that although they said at the appeal stage that there were 7 beneficiaries on the intestacy, at the trial at first instance, they did try to rely on a trust that they said they had created in August 22, where they held on trust for themselves. So, as they were presenting matters at trial, factually, they were saying, as things stand, we have an interest in possession. Although that wasn't the thrust of their argument. It was confused. I think I can do no more than point out the difficulties that arise from a factual point of view on that issue.
But in fact, on the appellant's case, it's not a question of fact at all. It follows as night follows day. If there is an intestacy for at least a period, there will be a grant. But at which point the trust under Section 33 applies and cuts off time running for the purposes of adverse possession claims.
Yes, and I think the appellant's cases, and I can't really argue against that the beneficiaries, until the estate has been administered, don't have an interest in possession.
Well, I think that's very sensible, if you don't mind my saying.
Those are my submissions, unless I can assist.
You have filed a respondent's notice. Different and or additional reasons. But I think they're sort of, well, it's page 51 of the bundle.
Yes. No, wrong one.
I mean, I think they largely replicate your submissions. There are some other points raised. For example, reason 2, the words trust, trustee and beneficiary are used elsewhere in the Act and the rules.
Yes.
In a manner which is consistent with, we don't have the rules at the moment.
No.
Is there anything that you wanted to say in respect of any of those points?
No, I've covered what I wish to, and no, I don't wish to expand those points, thank you.
No, very well. Okay. Thank you very much, Mr. Rogers. Sorry, I'm misreading this. I should have misnaming you, I'm afraid, Mr. Roberts. Apologies.
I did try to correct your lordship, but obviously
I'm
didn't
sorry.
say so loud enough.
Sorry about that. At least you-
But it happens.
At least you didn't have to say to me what counsel once said to me when I mispronounced his name when I was very first a judge. He said, well, somebody with a name like yours might at least know how to pronounce my name.
Fair enough.
At which point I mispronounced his name for the rest of the trial. Okay, that's
My
very
learned
helpful.
friend has kindly provided the court with the relevant section of the explanatory notes.
Yes.
The section to which I was referring to was on the first page of the bundle, and
Yeah, you got that. Thanks very much.
the relevant pages in the glossary at the end. And so the reference to a trust of land. Land can only be held on trust for beneficiaries, either under a trust for land or settlement.
Yeah.
Not necessarily sure that takes us any further.
No, I'm sure it does.
No,
either.
I'm not sure.
I mean, I think the more significant point is the one about paragraphs 271 and 272, which, as my lord pointed out earlier, really replicate what's in the joint report.
Yes.
Okay, thank you very much.
I only have a couple of points in reply. The first was in trust versus on trust.
Well, I'm not sure that's necessarily a very strong point.
Grateful for that indication, my lord. Then my learned friend did say at one point that in an unadministered estate, the beneficial interest is in the personal representatives. ALS says that's not the case, at least if we understand ownership and interest to be the same thing, which I think we must. I could take you to that or just give you the reference. I'm in your hands, really. The reference, anyway, is tab 11, 130.
Tab 11.
Page 130. The authorities.
Livingston did talk about the entire property being vested in personal representatives.
Yes,
Without
without
distinction in law
distinction,
Yes.
which is a slightly difficult phrase. Lord Diplock, it's more persuasive, it's the West binding, it's the House of Lords, not the Privy Council, it's more recent, he's considered Livingston, and what he says at its just under, is it E? I was thinking of a passage further up the page actually, but let me read that. Yes, the beneficial ownership is not vested in him. That's, I think, not specifically talking about a PR, but near the top under A, fourth line down, executorship of an estate in course of administration provides one example which does not owe its origin to statute. No one would suggest that an executor, who was not also a legatee, was beneficial owner as well as legal owner of any property which was in full ownership of the deceased before his death. So I say that clearly means that the beneficial interest or ownership is not in the personal representative. Anyway, it's a small point. The explanatory notes, Lord Justice Zacaroli pointed out that the purpose that it states that the paragraph 12 has only refers to one thing that it covers, not all things. There's also, for example, discretionary trusts, and I say charitable trusts. Picking up on charitable trusts, my learned friend referred to that passage in the explanatory notes, in the joint report about notification to the Charity Commission in cases of land held on charitable trusts. I did have a quick look at the rules. I couldn't see any reference to notice going to the Commission. What I say about that is that trust in paragraph 12 must include a charitable trust because it is, on any definition, a trust. Now, if it does include a charitable trust, that suggests, first, that paragraph 12 changes the law in respect of charitable trusts, because you could have adverse possession of land held in charitable trusts before the Land Registration Act 2002, and it suggests that the law has been changed without the joint report actually stating explicitly that it was going to change it. Now, if that's the case for charitable trusts, I say it can be the case for unadministered estates too. So if your lordships are to hold that I'm wrong about unadministered estates. I would say that the same thing would have to follow for charitable trusts. They go together. And so, in other words, well, they go together. That's the submission. The other point in the explanatory notes was just the glossary. It says what a trust of land is. Elsewhere in the joint report, it talks about trusts of land. It says that a trust in paragraph 12 means trust of land or settlement of land act settlement. It explains what a trust of land is. And clearly, a trust of land, as defined in the glossary, includes an unadministered estate. Section 18 of Talata says it does. So, in my submission, I think the authors were thinking about trusts of land, or to be stricter again, Parliament intended this to extend to trusts of land, therefore it must have intended it to extend to unadministered estates, as well as charitable land, for example. Those were all my submissions in reply.
Thank you very much indeed.
Very good.
Thank you, Mr. Kirby. Well, thank you both very much for your helpful submissions. We reserve our judgment, obviously, and we'll get you a judgment in draft as soon as possible. It's unlikely to be the side of Easter for obvious reasons. When you do get the draft judgment, please pay attention to the terms of the embargo at the top and make sure it's complied with, and also please, the purpose of you having it in draft is to point out any obvious typographical and similar errors, not to invite the court to rewrite the judgment in the way in which you'd like it written because it's been written in the way in which you don't like it. So, subject to those caveats, thank you very much indeed. When the vacation comes, have an enjoyable vacation.